Good morning, everyone. I'm Jane Fielding and I am head of the Employment, Labour and Equalities team here at Gowling in the UK. And I'm delighted that you're able to join us for what is the first in a series of 4 webinars on employment law, which we're putting on this year, perhaps for obvious reasons. We can't host you in our offices as we normally would in June to bring you up to date with what's happening at the mid-year point. Hopefully by January, when we look ahead to what's going on in 2021, we'll be back in the offices and able to have everybody in, as many people as can make it. And we're very much looking forward to that. But for now, these webinars are going to cover 4 topics. And today, our topic is holiday entitlement and holiday pay, which in the UK is surprisingly complicated, perhaps. And those of you who have to grapple with this in HR or legal, perhaps sometimes feel like you need a holiday once you've managed to sort all of this out. What we're going to cover today then is a refresher on where this entitlement comes from. Then we're obviously going to touch, given the current situation with coronavirus pandemic, managing holiday while we're all dealing with that. And then we're going to cover the case law that's been generated over the last few years about overtime and how you calculate that and what should be taken into account when you're working out holiday pay. So I'm going to bring you up to speed with the case law in that area. And then finally, we're going to cover the curious case of part-year workers. That isn't a typo for part-time workers, it is part-year workers. And that concept has been introduced by a case which we're going to talk about and bring you up to speed on in this webinar. So I'm just going to introduce the fellow speaker and then I'll do a few housekeeping points before I hand over. And Anna, if you could turn on your camera, is going to be in control of the slides today. Hi, Anna.
Hi, Jane.
So Anna's going to talk you through all of that. Before I hand over to her, I just wanted to give you a couple of housekeeping points, obviously less than if we were in person, don't need to do the fire alarm, evacuation, etc. During the webinar, you'll see at the bottom of your screen, you have a Q&A function. If you want to ask any questions, and we really would welcome those, please do use that function and type your questions in. While Anna's speaking, I'll be monitoring those, and we've factored in some time at the end of the session, of Anna's session, to answer as many of those questions as we can. Judging by previous experience, I don't think we'll get to all of them, but we will do our best to pick up as many as we can, as I say. And you'll also be prompted at the end of the webinar to provide some feedback to us. We'll be very grateful if you would do that. It only takes a couple of minutes, but we do read that and take it into account in shaping future sessions. So if you do have time, please do fill that in and send it back to us. So I will now hand over to you, Anna.
In terms of the refresher, can everybody hear? Hopefully that's fine. So if I start from the beginning, refresher on the working time regulations, 1998. I'll just touch on those briefly. Regulation 13 leave, that's our 4-week European leave, derives from the working time regulations and the working time directive. Regulation 13A leave, that's the 1.6 weeks leave that derives from domestic legislation contained in Regulation 13A. Notionally, it's to do with the bank holidays, but we don't have a statutory right to bank holidays. And then, of course, there's the contract of employment. The contract of employment. So I'm not quite sure what's happening with the slides. If I keep talking and you mind, if you don't mind listening, then hopefully we can go back to the slide that's headed up managing holiday during the pandemic. So in terms of managing holiday during the pandemic, there are essentially 3 areas that I wanted to cover. So the first is in relation to holiday for employees. Then there's accrual and carryover. And then there's the impact of quarantine arrangements. So looking at the next slide, this is the slide that deals with how you're going to deal with holiday entitlement during the pandemic. So these are unusual times, unprecedented times. I don't suppose anybody probably knew the word furlough before March, but we now have this situation where we have the coronavirus job retention scheme, employees being furloughed where there's no work for those employees, and obviously there's an impact there in relation to holiday entitlements. So there are 3 publications that are relevant here. The first relates to the ACAS guidance, which was published on the 31st of March. The ACAS guidance has been updated since, so it covers lots of issues. So it covers things like self-isolation and returning people to work. There's also the issue in relation to how you address and deal with your employees that's covered off in that guidance as well. The HMRC's guidance, the first guidance actually that was published in relation to holiday entitlement came out on the 17th of April, but it was the 4th version of the guidance. So no wonder everybody was sort of scratching their heads up until that point about what actually furlough and pandemic meant to holiday entitlement, holiday pay and so on. And then we had BEI's guidance introduced on the 13th of May. Now, all of those publications have a degree of commonality. So I thought what I'd do is draw together what they mean in practice. So we do now know that holiday is not broken by furlough, and that was a concern initially. We know that holiday continues to accrue during furlough. And we know that there is no kind of interference with employers' rights under Regulation 15 in relation to how employers can manage holiday. So if you want to request and require your workforce to take holiday, the default position is that Regulation 15 requires you to essentially serve notice, which is twice the period of the leave that you want the individual to take. If you want somebody to take 5 days leave, then the requirement is that you give them 10 days notice. If, on the other hand, you want to cancel or refuse a request for holiday, then the time limits are slightly different, but the counter notice provisions are quite similar. You have to give as the same amount of notice as the period of leave that the individual has either asked to take or you're wanting to cancel. So no change to that particular provision in relation to your right as an employer to manage holiday of the holidays of your workforce. So we also know from the various publications that there is a great deal of focus on engaging with the workforce, particularly if you need to explain to the workforce why you're going to require them to take leave. Because you can understand that for some individuals, at the moment, lockdown as it is, before we start to unlock, actually is quite challenging. It's difficult for some individuals, particularly those who are self-isolating, to see how on earth they can actually enjoy their rest and relaxation, the kind of benefits that you would expect to derive from holiday. So it's interesting because in the BEI's guidance says specifically that as an employer, you must consider when you're looking at requiring people to take leave, the restrictions that might apply to an individual employee, to the workforce, and that's in relation to things like social distancing and self-isolation to determine if that prevents the employee from resting, relaxing, or enjoying their leisure time. So that's creates a slight issue, which I'm going to come back to. We know that holiday pay has to be paid at 100%, in other words, normal pay. So that means if you've got people who are on furlough and are being paid 80% under the job retention scheme, then you're going to need to top up. And again, for some employers, that's going to have a serious impact. And then finally, we have the working time coronavirus amendment regulations, which I'm going to deal with specifically. So looking at that final bullet point in relation to bank holidays, not a huge amount of change. Obviously, if you've got an employee who is furloughed who would ordinarily work on a bank holiday, you're quite entitled as an employer to claim under the scheme for that day. If you've got somebody who wouldn't normally work on a bank holiday, then you can choose to pay them 100%. But equally, what you might decide to do is to redesignate the day and then give that person a day off in lieu in due course. So no great changes. And in fact, we've only obviously got one more bank holiday to deal with before the end of the coronavirus job retention scheme on the 31st of October. So if we turn to the next slide, looking at managing holiday during the pandemic. As I've said, it's really clear that working time holiday, so that's your entitlement under Regulations 13, will continue to accrue. Now, in relation to, under 13A will continue to accrue. Now, when it comes to the issue of carryover, that can be more complicated because you have to look specifically at the type of leave you're dealing with. So in relation to Regulation 13 leave, there has been up until March, as I'll explain later, a completely mandatory prohibition on any carryover of the first 4 weeks of holiday, the holiday that derives from the directive. There are a couple of exceptions. The most common exception I suspect people come across, and you'll be familiar, I'm sure, with the case of stringer, is where somebody is on long-term sick leave and that prevents them from being able to take their leave. So that's fine, that's quite well settled. It does have an impact, which I'll talk about in relation to how we're dealing with holiday during the pandemic, however. And then, of course, you've got maternity returners who'll come back to work with their full holiday entitlement intact. And in some cases, that can be quite problematic because it's very difficult for them to squeeze in an entire year's worth of leave for the end of the leave year. And in those cases, they'll be permitted to carry over. So far as Regulation 13A leave is concerned, the 1.4 weeks, then in that situation, it's possible for the employer to agree with the employee that leave can be carried over. And we see that quite regularly. And of course, the employer can enter into contractual arrangements around carryover if they wish to. So having looked at the particular provisions that existed up until the 26th of March, I thought that we'd now focus really on the impact of the working time amendment regulations. You can imagine the concern, and I'm sure many of you have shared this concern, amongst employers where you might have all of your workforce furloughed or some of your workforce furloughed and some people working where there's just no slack, no opportunity for people to take holiday because you need them at the coalface. In those situations, employers grew increasingly concerned that at the end of the furlough scheme, when people came back into work, then actually people would come back with huge swathes of leave entitlement to take, which would be really difficult to take before the end of the leave year. And with the use it or lose it provisions that apply to Regulation 13 leave, individual employees could also be really disadvantaged by the restrictions imposed by our original working time regulations. So as a result of that, these amending regulations were introduced as a temporary measure. And what they allow for is carryover. And what they say is where it's not reasonably practicable as a result of the effects of coronavirus on the worker and the employer specifically, and on society and the economy more broadly, then leave can be carried over. And it's not just about carryover into the next leave year, it actually allows the leave to be carried over into the next 2 leave years, that immediately followed the leave year in which the holiday should have been taken. So a huge relief, I suspect, for some employers, although if you look at the various guidance documents that have been published, there is clearly a huge focus on ensuring that people or employers are actively engaging with their workforce and trying to encourage people to take leave, because we can't lose sight of the fact that, of course, even if you're working from home, even if you're in the workplace at the moment, even if you can't go anywhere, at least as things stand today, you still need a break, you still need to have rest, and the whole purpose behind the working time regulations is that they're health and safety driven. So there is an issue about allowing people that time off. So there were a couple of things I wanted to pick up about the amending regulations. So in terms of those amending regulations, you might ask, what does reasonably or not reasonably practicable actually mean? Now, ACAS, when they issued their guidance on the 31st of March, gave 3 examples of where they thought that it would not be reasonably practicable for a holiday to be taken. The first is the most obvious, and that's where somebody is working, where there is no slack in the workforce and the employer can't allow anybody to take leave. That's pretty straightforward. The second example they refer to is where people are sick. Now, if you've got somebody who is on long-term sick, then the principles of Stringer are going to apply, but you may have people who are deemed sick, so if they're self-isolating, or for example, they're shielding, or in fact, they're people who are on furlough who are sick, but you leave them on furlough rather than moving them onto SSP. In those situations, you may have individuals who actually aren't able to take their leave. So this may be another situation where leave can be carried over at the end of the leave year. And then there's a really interesting addition, the third example that ACAS give is in relation to where people are on furlough. And obviously people who are on furlough aren't working, but just because you're on furlough doesn't mean that you can't enjoy your holiday when your holiday is designated. It may be that it's no different than the previous week because you're just at home not working. But ACAS gives that as an example, and I think it's a bit odd because it's not in keeping with some of the legislation or the legislative developments that have been dealt with in relation to the working time regulations over the years, and in particular a Supreme Court decision in a case called Russell and Transocean International. The principles from that case are fairly clear. If you are working, you're working, and if you're not working, you're resting. And the working time regulations really don't draw a distinction in any other way. So this is not about the quality of your rest. This is just about the fact that if you're not working, then you're resting. And that case involves some oil rig workers who worked 2 weeks of each month on the rigs and then 2 weeks off, and the employer designated leave in the period when they weren't on the rigs. And the Supreme Court said that was fine. So I'm not sure that that example that's given in the ACAS guidance would necessarily hold good, because I think that the fact is that if you're not working, you then you can be working. The employer can require that period to be a period of leave. So obviously lots of employers may be concerned about this from a cash flow perspective and not actually want to have people on holiday when they're on furlough because of the requirement to top up to full normal pay. So this gives those employers some comfort that actually people can still take their leave because the use it or lose it provisions as far as the Regulation 13 leave are concerned are disapplied. Obviously, you may find that employees are disgruntled by this, and so we may expect to see some grievances, but quite whether there is any case law that's likely to be developed here or any litigation that's got legs, it is really quite debatable. However, I think what it does do is it demonstrates the importance of ensuring that you keep accurate records of when leave is taken, so that if there is a challenge at a later date, you'll be really well placed to be able to respond, and you'll have accurate records that can be relied on. So I just want to move on now to the issue on the slide dealing with managing holiday during the pandemic, so far as quarantine is concerned. And obviously quite a novel concept introduced in June, some fairly prescriptive rules around quarantine. So mandatory 14-week period of self-isolation with extremely limited activity. I know there are some exceptions. There are some exceptions in relation to people in particular roles, but also there are some exceptions for those who are coming in from what are called the common travel areas. So if you've got somebody returning from the Republic of Ireland or coming back from the Isle of Man or the Channel Islands, they won't be subject to quarantine. Now, of course, quarantine isn't going to be an issue for employees where those employees are able to work from home. So I suppose theoretically, looking at the media coverage yesterday, I could jet out to Benidorm for a fortnight with Jane's approval, and then I could come back and I would just quarantine at home and I would just return to work. But if I'm somebody who has to work in the workplace, then clearly I'm not going to be allowed to do that because that's not allowed by the rules. So in those circumstances, how do you deal with that situation? So there are a couple of things to think about. Could you require the individual, if they've booked 2 weeks leave and they're going abroad and they're going to have to quarantine for 2 weeks, require them to take a further 2 weeks of leave? Is that actually compatible with the BEIS guidance? Is it reasonably practicable for that person to take their leave, given that actually they'll be self-isolating, and those self-isolating provisions are very stringent? It's not just a case of social distancing, for example. So maybe some challenge there. You might ask the individual to take unpaid leave. That may not be very popular, but that may be the alternative because they're not able to attend work and deliver the work which they're contractually obliged to do. There is some discussion out there about whether or not you could treat that person as being on sick leave. I think that that's highly unlikely, and I say that because although the statutory sick pay regulations have been amended to cover people who are self-isolating, those people are self-isolating on the basis of medical advice, so NHS advice. Somebody who comes back and has to quarantine and be in self-isolation for a 14-day period is doing that because of the quarantine requirements, not because of the fact that NHS has said that that's what they need to do. And as far as I'm aware, there is no suggestion by the DWP that they're going to change the regulations in relation to statutory sick pay again. And then there's a question, of course, about whether the individual actually went on holiday, that holiday was authorised, because if actually they just can't come into work, then we may be in a situation where absence, if they're not engaging with you, might end up being treated as unauthorised absence. So that's sort of where we are with the issues in relation to the pandemic. So lots of things unfolding, lots of potential for arguments in due course. I think the key message from the various publications is the importance of communicating with your workforce and ensuring that your workforce understand why it is you're asking them to do what you're asking them to do. And as I say, encouraging people to take a break, even as I say, if it means that it's a homecation, not even a staycation, but a homecation. Hopefully tomorrow will bring some, or later today will bring some happier news in relation to the uneasing of, or the easing of lockdown, so that there is more flexibility for people to get back into what we might describe as some form of normality and be able to take holiday. Okay, so we're going to move on now to look at overtime and where we are now. So on the next slide, what I want to do is just again as a refresher to remind everybody about how the employment tribunals now approach the issue of calculating a week's pay for the purposes of holiday pay. So the regulations in the working time regulations don't specifically contain a formula. What regulation 16 does is it directs employers to sections 221 to 224 of the Employment Rights Act. So when you then start looking at the detail of that legislation, and it is quite unwieldy, what we're quite clear about is that if you have normal working hours and your pay doesn't vary, then your average weekly pay, your weekly pay is based on your basic salary. If you do have a situation where your pay does vary with the work that's done or when that work's done, then you have to look at average earnings over a reference period. I'll come back to that in a moment. If you have no normal working hours, then again, it's average earnings over a reference period. So the question is, what's the reference period? Well, case law we tended to see in the case law reference to the 12-week reference period that was contained in the Employment Rights Act. But of course, that's now a much longer reference period as a result of changes that were introduced on the 6th of April. And those changes were introduced to give effect to the recommendations of the Taylor Review and the Good Work Plan. So that 52-week period, the idea is effectively what it does is it evens out somebody's average earnings, because you might have somebody who works a lot of overtime just ahead of holiday, so they get a bit of a windfall, if you like, when they're paid their week's pay for holiday pay purposes. But you might also have a situation where somebody's worked a lot of overtime in recent weeks and therefore their pay is sort of deflated. So the idea is just it equalises, creates something that's a bit more stable. That 52-week reference period, you can count back as far as 104 weeks because you discount any week in which no pay was received, but that seems to me to be unlikely in most circumstances. So moving on to the next slide, what I wanted to do, as Jane mentioned, was really just capture some of the more recent case law. So it might look odd that I've got reference there to Fulton and Bear Scotland, because it's a case that was decided by the Employment Appeal Tribunal way back in 2014, but it is relevant. And it's relevant for a couple of reasons. The first is that obviously what it did was confirm that if you have non-guaranteed overtime, so that's where you, the employer, can require the individual to work overtime, they have no entitlement to overtime, then that counts towards holiday pay, forms part of normal remuneration. The reason I've included it, however, is there were 2 points that were made in the case that are now subject to potential challenge. In Bear Scotland, the Employment Appeal Tribunal looked at the issue of the order in which you take your holiday. So do you take Regulation 13, the first 4 weeks first, followed by Regulation 13A, the 1.6 weeks second, and then any contractual entitlement on top of that? Well, that's what the Employment Appeal Tribunal in Bear Scotland decided. Regulation 13 goes first. Not so according to the Northern Ireland Court of Appeal in a case of the Chief Constable of Northern Ireland against Agnew. This is a much more recent case from last year. There they said actually there's no sort of running order, which actually makes it quite difficult, because if you think about the carryover provisions that are going to apply in relation to the pandemic and the amending regulations that were introduced in March, they only apply as far as Regulation 13 leave is concerned. So we could get some arguments around what sort of leave you're dealing with and whether there is that right to rely on those amending regulations. The other reason I wanted to touch on Bear Scotland as well is that in that case, you may remember that the court was very clear that if there was a break of more than 3 months between payments, then that broke the series of deductions. So when you brought your unlawful deduction of wages claim, if there was a break of more than 3 months, you couldn't go any further back. So you couldn't leapfrog back, potentially all the way back to the 1st of October 1998. Now, as a result of Bear Scotland, there were some further regulations introduced, the deduction of wages limitation regulations, which were introduced in 2014. They came into effect in January 2015. They limit back pay to a 2-year period. So to some extent, that means that employers have some comfort because at least you know where the long stop date is. Agnew, on the other hand, the Court of Appeal in Northern Ireland said actually that 3-month period doesn't break the series of deductions, so you can leapfrog back. Now, it's important to say that the Court of Appeal in Ireland, that doesn't bind the court here. However, it does give some scope for arguments based on Agnew being run here, and some potential challenge to the issue around series of deductions. So, as I say, I thought that it was relevant just to touch on that. What Bear Scotland left unanswered was the issue in relation to the whole piece around, I'm not sure if you can see that. Let me get rid of that in case it's obstructing my slides. Willits and Dudley Metropolitan Borough Council. In this particular case, this was a case that involved arguments around voluntary overtime. It involved 56 employees. It wasn't just overtime, it was a variety of other payments that they were paid. And the court basically said if payments were regular and settled, then they should be included in the calculation of holiday pay. And then we had a more recent case of Flowers in the East of England Ambulance Service. Here, ambulance workers were entitled to 2 forms of overtime payment. One was non-guaranteed, so clearly that counted. One related to voluntary overtime. And as a result of the decisions in the Employment Appeal Tribunal and the Court of Appeal, they decided that if payments of voluntary overtime were regular and recurring, then they should be included. So that case was given, well, there was leave to appeal given on the 12th of March. So it remains to be seen whether the Supreme Court come to the same conclusion, but it seems to me that the direction of travel is pretty clear. There is an issue, however, though, of course, you need to look at each case on its own facts, because it may well be that you can't establish the degree of regularity that's required. So moving on next to the rise of the part-year worker. And as Jane said, that's not a typo. This is a new term that has come into being, and I'm going to explain why. But starting with the premise of how you deal with holiday pay for people who are on 0-hour contracts and any kind of atypical worker. Now, it's been long established that a shorthand way of calculating entitlement and pay is to apply this 12.07%. Now, that comes from the calculation that's on the slide. So it's basically a 52-week year, reducing by the 5.6 weeks of annual leave down to 46.4 weeks. You then divide the 5.6 weeks leave by that 46.4 weeks, and you get this lovely percentage that allows you to determine entitlement and pay. So that's great. It was in the guidance. Everything was fine. We all understood that as this sort of golden formula. But then, and we'll come on to the next slide, we come to the case of Brazel and Harper Trust. that this is the rise of the part-year worker. So just to explain a little bit of detail, because it's relevant, it's highly relevant actually to where the court got to in its conclusions. So in this particular case, Mrs. Brazel was a music teacher. She worked for a school. She worked under a 0 hours permanent contract. She didn't work every week. She worked when she was required. Some years she'd work 32 weeks in the year, and sometimes she'd work 35. It just depended how many weeks there were where they were the school was in operation, and then she would take her holiday during the school holidays. So she was basically just working week to week during term time, and her contract provided that she was entitled to 5.6 weeks leave. So at the end of every term, what the school did was that they applied the golden formula. They applied the 12.07%, and then they paid her holiday. Mrs. Brazel looked at this and said, well, actually, I'm entitled to the full 5.6 weeks leave, and that's what I should be paid. So I've suffered an unlawful deduction of wages. The employer said, no, it needs to be proportionate to the work done. In effect, you can't have a situation where somebody who is part-time is being treated better than somebody who is full-time. Now, when Mrs. Brazel applied the sort of golden formula, if you like, to her calculations, and the way she did this was to say, well, you know, there's 46.4 weeks where you work in the of working time in the year where those weeks count. In her case, if you divided that by 32 weeks, then multiplied it by 12.07%, you get to 17.5%, and that's what she said her holiday should have been based on. And therefore, she said she was being underpaid. And the Employment Tribunal looked at this, and they said, well, actually, there should be prorating. You don't apply the 12-week average. You have to read words into the working time regulations. So we're going to say that you have to cap pay at 12.07%. The case was then appealed to the Employment Appeal Tribunal, and they agreed with Mrs. Brazel that, in fact, you looked at Regulation 16 and the provisions and the formula set out in the Employment Rights Act, and actually you should use the 12-week reference period, and that actually you could treat part-time workers more favourably than full-time workers, because although the part-time workers regulations contain provisions that mean it's unlawful to treat part-timers less favourably, there isn't a corresponding provision that means that full-timers can complain that they're being treated less favourably than part-timers. So the case then went to the Court of Appeal, and this is where the term part-year worker was coined. And this is somebody who works part of the year, but effectively is employed for the whole year. So you've got people who are working sporadic weeks on and off throughout the course of the year. So it's not like somebody who works part-time all of the year, and that's the real distinction. So in that case, the Court of Appeal said you don't need to prorate. What they said was basically Mrs. Brazel was entitled to 5.6 weeks leave. And it leads to some really odd outcomes. And this was something that was raised by the barrister acting for the trust, Casper Glynn QC, who gave an example of an individual who worked 1 week in the year. In that situation, if that individual worked 1 week in the year, they'd be entitled to 5.6 weeks leave. So if you assume that person is paid £1,000 for that 1 week, then they'd be entitled to holiday pay of £5,600, which is very odd that the court weren't persuaded. So moving on to the next slide, just to bring this session to a close, where are we with the situation following Brazel? Well, permanent workers are entitled to 5.6 weeks of leave regardless, and that formula may not actually now give the correct entitlement and pay for people who are part-year workers, so it's necessary to carry out specific calculations to work out what they should be paid. And the formula itself has now been removed from the BEIS guidance. And then just as a very final point, I'm very relieved that wasn't new guidance on holiday published yesterday, but what I can tell you is that Casper Glynn, representing the trust here, tweeted yesterday that leave to appeal to the Supreme Court was granted yesterday. So we wait with bated breath to see whether the rise of the part-year worker may be followed by the demise of the part-year worker. But as I say, it leads to some very strange situations, and it may well be that this is a a bit of an anomaly, and the position that existed before the Brazel litigation is restored after the Supreme Court has had an opportunity to look at the issue. But we'll keep you updated. So that's the end of the session. Apologies for the technical glitches earlier. Hope that's been useful, and we now have some time for questions.
Anna, yeah, we've had questions coming through. The first one relates to what you said about the new coronavirus regulations allowing carryover where it's not reasonably practicable to take the holiday. And the question is, do employers have to allow employees to carry over leave into the next year where they haven't used the holiday up just because they didn't want to take it in 2020? Or can employers in that situation refuse the carryover on the basis it was reasonably practicable for them to take it and they just didn't?
Well, it seems to me that the amending regulations don't really change the existing position. So if it was reasonably practicable for the worker, for the employee to take their holiday, then the same normal use it or lose it provisions will apply. But there is one thing I think to be aware of, and that's a case that was decided by the Court of Justice of the European Union. It's called Shimizu. And in that case, the court said that actually employers have to be, and the word they used was diligent, around drawing to the employee's attention the fact that leave will be lost. I think if you're in a situation where you can see as the employer, you're looking at your records, that an individual does have holiday entitlement that hasn't been used, and you consider that actually it is reasonably practicable for them to take it, I would suggest that you ensure that's drawn to the individual's attention and you make a record of that as well.
Okay, thank you. And then another question about the bank holidays that you touched on. Can an employer still claim furlough pay from HMRC for bank holidays where the employees are paid in full? I think that's indicating, it says we pay them in full, which presumably means they get paid for bank holidays when they work them.
I think if an individual would have worked the bank holiday, then there doesn't seem to be any problem with claiming under the scheme. I think it's where the individual doesn't ordinarily work a bank holiday. If they're on furlough, then the employer will have to top up. They can only claim the 80% under the scheme. And if you don't want to do that, then you're going to have to redesignate the day and give that person a day in lieu at a later date.
Okay, we've had a request for a full case citation, but I think we'll send that through by email afterwards. So whoever sent that, don't worry, we'll get back to you by email. And then just finally, what if the employee has booked leave before any of the coronavirus pandemic kicked off and they now want to cancel that leave? What can employers do then?
Okay, the starting point is to say that there isn't an obligation on the employer to agree to that. However, I think it would be really sensible to actually explore why it is that the individual wants to cancel leave. If they're going to argue that it's because actually they're not going to be able to enjoy their holiday and there is some merit in that argument, then you may agree. The other thing, of course, is if you've got a situation where the individual actually, it turns out that they're actually sick, and it may be you've got a furloughed employee who doesn't tell you that they're sick and they just have remained on furlough, then you need to bear in mind the existing case law that says that there is an entitlement to rebook. So I think, again, as with all of these things, it's about exploring the reasons why the request has been made and then making an informed decision.
Yeah, there's the law and then there's employee relations as well, isn't there?
Indeed.
Okay. Well, thank you very much, everybody, for listening. We've come to our 40 minutes, so we'll draw it to a close. As I said earlier, you will get a feedback request, so if you could fill that in so we can take it into account, that would be excellent. If you can join us on Thursday for our next webinar, we'll be discussing confidentiality issues. But otherwise, thank you very much to you, Anna, for presenting and fielding the questions. And thank you to everybody for listening. Enjoy the rest of your day.